we'll move on to the next set of questions for this episode. Can a will be updated or revoked? Or once a will is written, it's cast in stone?
Well, I would say that the law actually permits a testator, the person who has made a will, to actually make any changes that the person wants to the will. So you can make changes through a codicil, or you can actually revoke the will and make a new one. Because sometimes you would acquire new properties, or sometimes the testator changes his mind about who he intends to give the property to. So it's very important. So
is there a number of times that you can change your mind?
No, there is no number of times. As many as you wish, you can change your mind. Just make sure that once you do it, you deposit it in the High Court.
So I want us to clearly distinguish between the updating and then the revocation. So we're talking about updating. What do we mean when we say we are updating a will? And what do we mean when we say we are revoking the will?
You want to come in?
Updating a will may mean you are either you are making changes to the will that has been made. The changes may either be addition or subtraction. So you may decide to add to what you have written already, or to reduce or take from what you have written already. All these come in the form of updating the will. Now, and she mentioned revocation. Usually, because you have written the previous one, which has gone in as you usually would state it is your last will and testament.
Mm-hmm.
So that if that is your last will and testament, and this is this subsequent one that is coming, the subsequent one must revoke the one that already is existing.
Okay.
So that will now become you take the position of the existing one. The new one will replace the one that is being updated.
Okay.
It's clear.
So it's the dates that are used to identify the newest one, right?
Yes. Okay. Yes, you can say that. Yes.
So I heard that if you want to revoke a will, you can just tear the will apart. How true is that?
Well, if you tear your copy of the will apart, you actually haven't done anything, especially if you have already deposited one in the court, because the one in court will still be valid.
Oh, okay. So wills must be filed in court.
Yes. Yes.
Oh, I see. So can I just get up and carry your will that I'm going to file in court?
Yes, you can.
Okay.
So what happens is that you go to the registrar, the probate and administration, and you have to send 3 copies of the will to courts. And when you go, you have to go with your ID as well as your passport picture. Okay, and over there, they seal the will. They will make sure they have this candle thing that they use in sealing the will. So they'll seal the will and make sure that the will is intact. And they have a registry that they actually deposit those wills in. And afterwards, they give you back 2 copies. So assuming you have a lawyer, you give one to your lawyer and you also keep one. Or whoever you want to give it to, you give one to the person and then you keep one. But anybody can go to court to actually go and deposit a will if the person wants to. And also, if, let's say, a testator dies and you're going through the testator's things and you find that the testator has made a will, what do? In such a situation, you have 14 days after the death of the person to actually go and deposit that will in court. So no matter what it is, it must be deposited in court. Whether you are alive or after the person dies, it must still be deposited in court.
Yes.
So that is actually a duty that the law creates for anybody who comes into possession of the will of a person who has died. The law creates a duty on any person who has seen the will to deposit the will at the registry of the court.
So if you breach that duty, what happens? I'll just hide it because my name was not in.
Now you fall foul of the law.
And
the legal consequence may follow.
Well, if you are found out, let's assume nobody knows, then you are safe. But if you are found out, yes, you can be prosecuted.
Delving into another crucial aspect of making of a will. Earlier on, we mentioned that there should be a named executor in the will. But we also heard of a story from one of our guests that even though persons were named as executors in her father's will, they decided that they were afraid for their life because of the way the family members were treating them after the death of your father. In that case, what happens? Does that mean that's the end of the beneficiaries named under the will? But before you even go there, I would like you to talk about the role of the executor. And then you divert into what happens if these executors decide that, please, I didn't ask for this, I can't do it. What happens? Is there a remedy available?
Yeah, certainly there are remedies available under the law for anybody who finds herself in this circumstance. Now, the executor's role commences or begins after the testator is dead, when the will is to be put in effect. Whereas the executors now stand in the position of the testator to administer the will. So that is the executors who put the will into effect, who pursue the terms of the will and act or do as the testator has wished in the will. So that if the testator directs that property A be given to Mr. V, the executor will do as has been required under the will. When the executors fail to perform their role under the will, there's a procedure that the beneficiaries can actually have recourse to for ensuring that whatever is given to them under the will does not go waste or they don't lose anything at all.
Yes, so the procedure is that in such a circumstance, what happens is you have to go to court, okay? And you can bring an application, or let's say you bring a probate action. You bring a probate action asking the executors to actually renounce probate, since they said they do not want to act or they are failing to act, because the executor has 1 year within which to round up the estates of the deceased. So once he or she has failed to do that, okay, she in the sense of an executrix. So once he has failed to do that, then what do? You can go to court, bring a probate action, and ask the court to ensure that the executor acts. Also, where the executor fails to do it regardless, or let's say the executor says that he doesn't want to do it and maybe as a result of incapacity or for one reason or the other. So just to cut a long story short, you decide that, okay, so what can I do in this instance? What's my remedy? What can I do? The Administration of Estates Act actually allows you to go to court and bring an application. First and foremost, you go to the Administrator General, you send an application to him and find out if he can administer the estates of the testator. So you're actually left with a remedy. You don't have to sit down and just cry and say that I don't know what to do. I think the law has taken care of that for us. So you can go to the Administrator General. You can also go to court for the court to appoint. Yes.
That's very interesting to know.
There's also a procedure, I think, under the High Court Civil Procedure Rules, CR 47 or so, where they can take another route, applying to the court for letters of administration.
Yes, with the will annexed. Yes.
That helps also.
So, my dear bereaved friend, you have a remedy. You don't have to sit and cry, as Lawyer Paulina has mentioned. There's always a remedy. It's just ignorance that sometimes make us go through all the things that we go through. If you listened to to some of the stories we've heard, it will break your heart. And it's only because they didn't know that there was a remedy. Yes, there is a remedy. Just find the right places to get the knowledge that you seek. And so I'm happy that you are listening to this. And I'm happy that you are going to tell your friend about it. You're also going to advise your family members and other loved ones. And you're also going to advise yourself to make a will. So I keep making reference to our previous episodes because these stories are real stories. These are not made up stories. You heard of Auntie Isabel's situation where the family members came asking her mom and other siblings to leave the property of their dad after the death of their father. Is there anything that a beneficiary, a spouse, children could do in such a situation? Because it's very heartbreaking that the person who protects you is no more, and the family that you seek to rely on are the same people coming to sack you from maybe a house that you've lived all your life. Is there any remedy?
Yeah, that certainly is a remedy under the law for the protection of persons who feel threatened or under the threat of family members who want to take out a property that their deceased relative owned or deceased father or mother. Now, the dealing with the estate of a deceased person requires that you must have authority to deal with the property. In the absence of such authority, you would actually be committing a criminal offense if you go ahead to deal with the property of the deceased person without the authority. And the authority, since we are talking about the wills, will be whether you are an executor or not. If you are not an executor and the person has died and you have gone ahead because you think that you are the head of the family or you are a sibling or however the relationship may be with the deceased person, you think that you can take over the properties of the person, you are actually committing a criminal offense.
Okay. So that means that it doesn't matter the number of years this happened. If you're so bizarre, you can still go after these people because criminal action, there's no statute of limitation. This one, I'm telling you.
Yeah, so that is so. So it doesn't matter whether it has happened now or it's happened so many years before. If the persons who committed the offense are still alive, it means that the law can still go against them.
Great. We've had very sound discussion from our panelists, but I want to ask, what if I don't make a will?
Well, if you do not make a will, if a person does not make a will, the person is said to have died interstate, as opposed to a person who died leaving behind a will, who is said to have died testate. So, with that regard, we have PNDC Law 111, which will come in and actually help with the distribution of the person's estate.
Okay.
Yes. So it's as simple as that.
Yes. So like the case of wills, where on the death of the person who has made the will, the executors have authority to deal with the property. When a person dies without making a will, who would be said to have died intestate? Now, you don't also go ahead to start dealing with the property of the person. You need to also obtain authority from the court before you can deal with the property of the person. In your failure to obtain that authority, you will be committing the same offense that the person would have committed under the will, who, although not being an executor, the person decided to deal with the property of the deceased person. So in this case, it would usually apply to the court, right?
Yes. By letters of administration, you ask for letters of administration, and you ask for letters of administration. So usually there is a hierarchy in the order in which the letters of administration is granted. We have the surviving spouse, then we have the children, then we have the parents, and then a customary successor. So in that order. So if there is a surviving spouse, she or he has the first right to apply, unless she says that she will not do it. Then any of the other people can actually come in that position. Yes, in that line. Not that the customary successor gets up and goes to apply for letters of administration when there is a surviving spouse, there are children, and also when there are parents who are surviving. Okay. Yes, so you would have to wait. You have to wait your turn, if I should put it that way. Yes.
So I want to add that the mention of children does not mean that there must be children who are born in a marriage.
Yes.
So even children born out of wedlock, they are entitled under the law to be able to apply for letters of administration.
Yes.
Maybe I'll invite you another time to talk about that aspect into details. So the choice is yours. You have two options. Either you make a will and decide who handles your assets, or how you determine how your assets should be used in your absence. If you choose not to, well, there's PNDC Law 111 that would also determine how these assets should be distributed in your absence. There's always a remedy, but you don't have to be ignorant of that. I would ask you, what would be your advice to any Ghanaian who have not yet made a will?
Yeah,
I'll first start with Mr. Shaibu and then move on to.
I'll begin from your last point where you said that there's always a remedy. So that I would advise that we don't even need to go for the remedy. Let's just prevent it. So that with the prevention, there will not be need for us to go around looking for the remedy. So the good thing is for you to make sure that whatever wishes you have about the distribution of your property when you are no more is provided and clarified in a piece of document, so that whilst you are resting in peace, the properties are distributed also in peace.
Okay. What do you also have to say?
I would agree with Lawyer Lateef and say that it's also very important that you make the will, because when it comes to the interpretation of a will, the courts look at it within the four corners of the will. What they say is that they sit in the chair of the testator and look at it within those four corners of the document and interpret it as such, meaning that there is nothing that is going to come from outside. No story, nothing. It's just what you intended. And that is what the court is going to look at. So because of that, it's very important such that you are able to give your properties to the people that you want it to be given to them. Not that your customary successor will come from somewhere and say that because I'm the customary successor and there is PNDC Law 111, I need somebody to do my bidding so that I can distribute the property to the person. Actually cannot happen, because if you're under PNDC Law 111, there is a way that the properties must be distributed. So somebody cannot just get up and say that because the person died without leaving behind a will, the person is just going to distribute the property. It must be done in accordance with PNDC Law 111.
Thank you so much. But before we leave, I want us to bust some myths. So if I make that statement, if it's a myth or a fact, you will state whether it's a myth or fact. So I would ask a few questions. So myth or fact?
Okay.
Do you need a lawyer to make a will?
The myth.
It's a myth, yes. Because if you can read and write, even if you cannot read and write, and you can write your will in very simple terms, in plain language, no ambiguity.
Meeting all the requirements.
Meeting all the requirements that we talked about earlier. Yes, you are good to go. Because in other jurisdictions, you can get actually will pacts that you can use. But in Ghana, we do not have that now. But if you can meet the requirements under the Wills Act, you're good to go, yes.
So let me add that even under the Wills Act, the law provides that the testator either makes the will by himself,
yes,
or directs another person to write the will for the
him.
testator. So that the requirement may not be so much about whether or not the person is a lawyer, but rather whether or not the person can write and appreciates what they write. So even if the testator cannot write and another person writes for the testator, the law requires that there has to be a provision where it is explained that the testator, before he signs on the will, the terms of the will have been explained to the testator in the language that he understands and he understood before he made his mark or before he signed, which is a jurat, right?
Yeah, that's a jurat
Yes.
clause.
So it is not necessary that there must be a lawyer before a will can be effectively made.
Okay. Thank you so much. Husband and wife, can they make a will together? Because I mean, the two shall become one.
Yes, a husband and wife can make a will together. So that's a joint will. It's possible. It just has to meet all the requirements.
So thank you for joining us for today's episode. If you have questions, feel free to ask in the comment section. If you have any comments, also do same. We'll be there to respond. Like, share, and subscribe to our channel. Abusia Bain, don't be that victim. You always have the choice. Bye.